All right, good. Well, I'm here with Molly Kirkland, Director of Public Affairs for the Southern California Rental Housing Association. Molly and I have done presentations and appearances on a couple different places, including the radio with Aubrey Morrow.
They're radio stars.
Yes, radio stars. And now we're going to be video stars, which is exciting.
There you go.
And I wanted to sit down with Molly because we're coming into the tail end of 2019. The legislature in California just voted on a rent control, rent cap bill, AB 1482, and it passed, surprisingly.
Or not.
Well, not surprisingly. I was quite surprised because I was talking about this with Alan Pentico when I interviewed him in this very room about how last November of 2018 we were here fighting rent control.
Absolutely.
And we thought that we had defeated rent control. And of course now suddenly we find ourselves under rent control starting in 2020. So what are your thoughts on that?
It's interesting. So it's very different when you have the entire voting population of California weighing in than it is when you have 80 assembly members and 40 senators kind of deciding that instead, and the governor ultimately. I will say, we had high hopes that we'd be able to stop the bill early on, and we were very close in May during one of the legislative deadlines. The bill did not have enough votes to get out, and we were really, really confident that we could stop it there. And unfortunately, another organization went sideways and gave the bill kind of the political cover it needed to get out of the assembly, and then it just sailed through from there. So at that point, when the governor stepped in, we knew that we weren't stopping this bill. He clearly wanted something to come to his desk, and when he got involved in actually negotiating the finer details, it was a pretty, clear indicator of where it was going.
Yeah, it seemed like the bill changed after it was agreed upon. It changed to become a more stricter bill, I guess. And then by the time it got to the governor's office, it became even stricter more towards the end there. But I guess that's politics. That probably doesn't surprise you at this point.
Not at all. I mean, bills go through all kinds of iterations and get amendments. What was interesting, though, about this one, you're right, it started off in similar form that we have now with a 5% cap plus CPI. And then the agreement that was negotiated would have raised that to 7%. And the bill at that stage included no just cause provisions. It was when it got back over to the Senate that percentage was again lowered back down to 5%. And they rammed in all these just cause provisions, and what we basically have before us now.
So there were a lot of changes. And that's why I wanted to sit down with Molly, because she certainly is the person that would know all the details. I speak to you as a broker selling rental properties and apartment buildings. I speak with owners, as you know, all day long, and they're not all totally clear on what the bill entails. And so that's why I thought it would be important that we sit down, spend some time kind of going line item through line item. I know you're the right person for that. You guys are offering classes on that. Before we jump into it, do we want to maybe talk about those classes that you guys are offering for folks that want to learn more about what's going on with the bill?
Yeah, sure. And I don't have the dates in front of me, but those are available at our website and our training calendar. We initially set out and we scheduled 4 classes specifically just for AB 1482. Those sold out in a matter of days, so we added 4 more classes. We've done 2 so far, so there's still an opportunity to get into a class. We are training members and non-members alike, and it's a really good forum to get all your questions answered on the bill, because the reality is when you go through the legislation itself, it's fairly quick. It's the Q&A period that takes a lot, because legislation is sometimes subjective. You've got to interpret it, and quite frankly, you say I'm the expert on this. A lot of this is clear as mud. So I learn something new every day on this. So the trainings, as much as they serve to benefit owners and managers out there, I actually learn in the process too. So it's a good thing.
Perfect. Well, and that's why I always encourage, Molly, and you know that we're all out there encouraging folks to join the Southern California Rental Housing Association, because quite candidly, this bill got through, but it wasn't for lack of effort for the association at the local level and at the state level. I know you guys were fighting to the very end to keep this bill from passing, and it was just inevitable. I guess they had set their minds. We're in a supermajority Democratic legislator here in California, so it's now here, it's with us. So why don't we start from the top? And by the way, we'll put a link to the classes in the description. So if you want to sign up for one of the classes, I know I signed up right away. I'm looking forward to attending that class. We'll put a link in the description field. But why don't we start from the top? The association has put together a handy bullet point document, and if you're a member of the association, you should be receiving this in your email here pretty soon. But let's clarify some confusion. So I'll go ahead and read them, and then maybe you can kind of do some clarity. And,
okay, I'll do my best.
And then we'll go from there. So, okay, rent control, AB 1482, CHU, CHIU, who is the San Francisco assemblyman who wrote the bill, the original bill, who is, by the way, a Harvard-trained attorney, which is maybe why these bills can be a little confusing. And Governor Newsom has signed AB 1482, and here are the basics. Number one, right on the top of the list, rent increases in any 12-month period will be limited to 5% plus the change in inflation from April 1st of the prior year to April 1st of the current year, as measured by the consumer price CPI for the area in which the property is located. Okay, so 5% plus CPI measured from April to April.
Right. So essentially, the Bureau of Labor Statistics puts out indexes for certain areas. And in California, I believe it's San Francisco, LA, Riverside, and San Diego. And they track the consumer price index and any changes in that. And quite often that's what is referred to for inflation. Now, in areas that don't have a publication or a figure from the Bureau, they'll go by the California Consumer Price Index. And there is a tool on the Department of Industrial Relations website where you can go in and actually put in a month, a year, and the particular region you're looking for to determine that figure. The problem for us right now is the bill is very specific that it's the change in inflation from April of one year to April of the following year. In San Diego and Riverside counties, the Bureau of Labor Statistics publishes every other month in odd months. So we don't necessarily get something at the end of April saying what it was at the beginning of April. So we've kind of gone back and forth with different attorneys and others to interpret this, and even talked to consultants at the Assembly Housing Committee via our lobbying firm in Sacramento. And we've been advised that the 2.2 figure for the San Diego region is the change in inflation. That's actually based on March to March numbers, which we think will be okay in the first year because that's what will be in place on April 1. But we've got to get some clarity going forward, and we're hoping that we'll get some cleanup language into a bill next year to make that clearer for those regions.
Certainly confusing, because as you and I discussed before we went on camera, I had a document here that was straight from the Bureau of Labor Statistics, and I went to 3 or 4 different websites, and I came up with 1.7.
Right, and so that's the confusion with a lot of folks. I've heard different interpretations of what the figure should be. I think the publication you're looking at is from September. Other people have pulled from other months, and this is what we should go by. So right now, again, we are using the March to March figure. It is a kind of conservative approach, if you will, because I think one could argue, well, there isn't a publication in that particular month for the region, so we can use the state figure, which is actually more like 3.3%. But we're saying, we would hate to see somebody sued on a technicality on either sides of the coin. Err on the side of caution. Do the 2.2 on top of the 5 for now.
Got it. So 5% plus 2.2 or somewhere thereabouts is the safe place. So 7.2% as of today. Okay. Not very clear, not at all. I mean, if you needed to contact 3 attorneys plus a political lobbying firm to get what the actual number is, it's going to be challenging.
And there's still debate amongst some of the attorneys even, so it's and we can talk about that as we get into this, but I think a lot of this will ultimately be decided in courts, unfortunately.
Got it. Okay, next item. we'll skip this one on the 2.2. I think we kind of covered that. You will be able to increase rent up to 2 times a year, but you are still limited to the annual cap.
Right. So we've been saying that you really are limited to 1 annual increase, which isn't necessarily true, but you're still limited to that annual cap. So most folks are saying, I'm just going to do it all in one fell swoop to keep it simple. But yes, you are technically limited to that cap. You could do it twice a year. So let's say the cap is 7% and you did 3% in February. Well, at some point later in that 12-month period, you can do the remaining 4% or whatever the case may be, and then that would be fine, but you would not be able to do anything again until that following February, and at that point, you would probably be limited to whatever you did the previous February. It's kind of written oddly, so we're not necessarily clear on that, but we are saying go by anniversary of when you did the increase. So that's why we're saying it's easier just to do it all at once, right? Versus
Sure.
having to track your percentages and your anniversary dates, and just make it clear and pick 1 month where you're going to do your increase and then go on from there.
Got it. So I have 2 questions that came out of that. So first, the anniversary. You mentioned the anniversary. You're not talking about April. You're talking about whatever day it is that
You do.
on your lease you do an increase or provide notice of an increase to the tenants. That is considered your anniversary, and the clock starts ticking from that date, correct?
Exactly. A lot of folks are thinking it's calendar year because the bill itself goes into effect January 1, but really the way it reads is in any 12-month period. So that first rent increase, for all intents and purposes, is like your first anniversary date. That'll dictate when you can do the next one if you used up your entire percentage. If you've got another, percentage you're available to tap into later, you can do that. But when you got to that first anniversary, essentially, you'd be limited on what that first increase was, if that makes sense. It's that 12-month period that kind of makes things a little funny.
So it's extremely important that going forward, if you haven't already done so since March of this year, that going forward, you very much should document that very first increase, because
Absolutely.
that's going to be kind of your line in the sand.
Exactly.
And going forward, you can run the 12 months off of that date.
Right.
So then my second question is, Molly, the annual cap. Now I know that the annual cap is essentially the rent cap of 7.5 or 7.2%, but there's another annual cap that is 10% total that is written into the bill.
The way the bill is written essentially is rents are capped at 5% plus the change in CPI, never to go over 10%. So let's say the change in the CPI was 6.5%. Well, you couldn't take an 11.5% rent increase. You'd still be limited to 10.
Got it.
Yeah.
Okay, that makes sense. Reality is most of the folks I talk to aren't even doing 5% rent increases on a regular basis. I mean, that is the majority of the people that I speak with. But I talk to a lot of independent owners.
As do I, and I'm hearing very much the same.
Right. Okay. Although they said now they may. So let's see here. Okay, next item. If you increased rent between March 15th of this year, 2019, so in the past, this last March, and January 1st of 2020, so this coming January when the bill comes out, and the amount is over the allowable increase, you will have to adjust your rent back. The applicable rent on January 1st, 2020 shall be the rent as of March 15th, 2019, plus the maximal permissible increase.
Right.
What does that mean?
This is essentially a retroactive provision. And if you were involved in National City last year, and I know you were, you'll remember that ballot measure had a similar provision in there. It calculated your base rent as whatever your rent was on a specific day in March. And the reason that these are put in is because rent control triggers panic in the marketplace when you start talking about it. And they know that, like you said, most owners don't take those large increases. And I talked to quite a few who don't do rent increases at all and are very
Right.
below market. And they know that when rent control is discussed or is pending, that these owners will go out and start doing rent increases. and they want to stop that. In this case, they've created a scenario that if you did a rent increase in the interim that is over what's the allowable increase come January 1, that you will have to adjust it back down. So you did a 20% increase trying to get close to market, well, you're going to have to take the rent back down to what the rent was plus the 7%, essentially. The nice thing in the legislation, I will say, is that they actually put it in language that says you don't owe the tenant the difference in that time period. So if they overpaid in 2019, that's fine. You don't have to reimburse them, but you will have to send them some notice in advance of January 1, letting them know that starting January 1, their rent is going to be X.
Got it. So it's retroactive back to March 15th of 2019. That's an important date. A lot of people are confused about that date, but again, it's March 15th, 2019. March 15th of this year.
And that retroactivity only applies to rent increases. I've had some folks think that that means the just cause provisions and that they can't do notices right now, but that's not the case. So as long as any notices to terminate tenancy that are issued in 2019, the termination date is, at the end, before the end of the year, essentially, those will be fine. If those termination notices carry over into January, that could be an issue.
Got it. Okay, next item. Vacancy decontrol remains intact. You will be able to reset your rents to market rate upon all original tenants vacating. Vacancy decontrol. Before we jump into the explanation here, vacancy decontrol always confuses me. So maybe explain vacancy decontrol in its actual language.
Absolutely. Vacancy decontrol is one of those sacred cows for the industry, especially in a rent control jurisdiction. And it's one of the core components of the Costa-Hawkins Rental Housing Act that we fought so hard to preserve last year. And that means essentially your ability to reset the rent to market rate when all original tenants vacate. And so what we used to see in rent control jurisdictions like in Santa Monica, for instance, was you had a tenant in place in a rent controlled unit, they would move, and then somebody else would come in and they were still telling you what that rent would be at that time. What vacancy decontrol says is that tenant moves, you, Mr. Property Owner, can now increase the rent to market rate, get that new tenant in there, and then you'll be subject to the controls from that point on. But vacancy decontrol is very important for getting closer to market rate, especially in rent control scenario. It's very important to be able to do the upkeep on your buildings over time. As tenants vacate, that is an opportunity that you might not otherwise have. So that remains as a part of this legislation as well. So if all your original tenants leave your unit, you can go to market, and then you'll be subject to the caps from that point forward.
In fact, that was going to be my question. So you're not talking about vacating the whole building. You're talking about just the original tenants that are on the lease within the unit.
Correct.
Now, why do you say original tenants? Is there some confusion as to maybe add-on tenants after the fact?
Yes. So, essentially you have to have a true vacancy. It can't be that, they switched roommates and now that means you're out of here or something like that. So it's either going to be the scenario where the tenants gave notice to vacate and everybody moves out, or if you had cause, you gave a 60-day and that's why everybody's leaving.
Well, that's good. That's good for the folks that have really low rents. We're also seeing it in our business that buyers are preferring maybe some of the the units to be vacant because it gives them the opportunity to bring it to market rate. Because otherwise it just doesn't make sense for buyers right now with some of these rents being as low as they are. So that will be a good part of at least the transactional industry on our side.
Yeah, and that was one thing that we actually asked during session, maybe for the author to consider some sort of pass through. If it's a one-time go to market, if you've been dramatically below, or a one-time go to market if you are taking over a building that was dramatically below market. We even asked for a kind of capital improvement pass through, and all that fell on deaf ears.
All right, next item. This bill is set to sunset in 10 years.
Yes.
It started off as 3 years. And then, wow, it got tripled to 10 years.
I think at some point it was 5, and then at some point I think somebody talked about 7 and 15 and 10. It's been all over the place, but yeah. So now we have 10 years. The feeling about that is just kind of it's there. There's no guarantees, and that was probably one of our biggest concerns with the legislation itself was. Nothing in here prevents the legislature from coming back in 2 years and lowering that 5% to 3%. And 2 years later, lowering that 3% down to 1%. And what we know from talking to other industry folks across the country and in California, that there have been scenarios in the past where the industry negotiated in good faith on something like this, agreed to a percentage, only to see that chipped away at over time. So what we said is we need something in here, if possible, that will give us the kind of certainty we need against this percentage being chipped away at. And the best idea we had was for the legislature to introduce what's called a constitutional amendment. And it has a little bit different process, but essentially that is something that ends up on the ballot as a measure. So we said if something's crafted well, we will support it, get it on the ballot, and then it'll be in place and it won't be able to be touched except by the voters. So now we're in a situation where we don't have that certainty and we are kind of at the mercy of the legislature if they decide, you know what, we've seen that all these landlords are actually taking the 5% plus CPI and people are complaining it's too high. And I should say, tenants' rights groups have already said that they think the percentage should just be a flat 2 or just CPI. So I have no doubt that there will be attempts to come back and chip away at that percentage.
And so sunset is a political term. That just means that the bill's going to go away at that time, or?
It could mean that. However, if something's set to sunset, they can re-up it, essentially. And we saw this several years ago with the SCRHA Act, which was a pilot program to fund different issue areas in certain jurisdictions, and we have unlawful detainers here in San Diego. So it's taking a portion of filing fees from property owners and giving it to a legal aid contingency to represent tenants. Now that was set to sunset, and they just re-upped and made that program permanent.
Wow.
So anything's possible.
What does it take to make it permanent? Does it just take a vote of the assembly?
Yeah.
Both sides, and then the government, like the same way a bill goes through?
Yeah.
Interesting. Okay, so now we're going to get into the just cause termination piece. So this piece was added after the fact, which was interesting to me because it was a failed bill, and then after it cleared the assembly, it seemed that they added this piece to the rent cap bill, and this actually became more of an issue than the original bill for rent caps. It seemed like it became more of contentious piece, and it's just cause termination.
So you're right. There were actually 2 bills at the onset of session that had to do with just cause. And at some point, those authors kind of came together and agreed that they were going to push one over the other. But nevertheless, those bills did not get enough votes to get out of the assembly at the legislative deadline. So for all intents and purposes, the assembly did not approve any just cause. They just approved this rent cap portion. It's when it got over to the Senate and the governor stepped in and everybody else that they rammed in these just cause provisions, which I admit I'm not surprised by. We have just cause in the city of San Diego and have for 15 years or so now. And what was shocking about that at the time is just cause usually goes hand in hand with rent control, because to kind of prevent landlords from terminating tenancies to go to market, they make you have cause. And so I think whether it was the governor or somebody else in leadership who determined, if we're going to have a rent control bill, essentially we need to have some just cause protections in there for renters. The problem, as we know, with just cause in the city of San Diego, it actually ends up harming good renters a lot of the time over the bad actors, and it makes it a lot more difficult to get bad actors out.
Absolutely. So, just cause termination will be implemented statewide, and kick in at 12 months of tenancy if all tenants have occupied the unit for 12 months or more. If there has been changes in occupancy, then just cause takes effect at 24 months. Okay, so let's break it down. 12 months, the original tenants are in there, what happens?
If they've both been in place, for the entire 12 months, then once they've lived there a year, they'll be under just cause.
Okay.
If there was a change in roommates or something in the interim, then it may not kick in until 24 months because all tenants have to have been there at least 12 months.
Okay.
So if they did a roommate change at some point, that could change that timeline.
So original tenants on the original lease intact, 12 months, now they're at just cause.
Yep.
12 months plus 1 day, or is it once they get past
Good
12
question.
months?
Okay. It says 12 months now, is that?
So at 24 months, if there's been any changes to the original tenancy, then now it just cause kicks in. Got it. Okay. Next item. Just cause applies to month-to-month tenancies and fixed terms lease renewals. So anybody.
Yeah, essentially. And there's sometimes property owners and managers think, well, but I'm in a fixed term lease and it's going to expire in this day. And typically, 60-day notices are for month-to-month tenancies. So sometimes they think they can just let it end. And it's not going to be the case if your tenants are in a just cause phase. Even if you're in a fixed term lease, let's say, you'll still have to give them the proper noticing period and have cause, or if you don't, repay relocation. But nevertheless, it applies regardless of your lease term, I guess is the best way to say that.
Got it. So month to month or in a fixed term lease, regardless, just cause is in effect. Okay, next item. At fault terminations include, but are not limited to. So now these are where you have the ability, that you have the just cause. At fault is synonymous with just cause, means that they did something wrong and you have the ability to terminate their tenancy.
Right.
Non-payment of rent, number one. Okay, so if they don't pay rent, you can kick them out. Probably not a good term. They don't pay rent, you can provide notice to
right.
move.
Or you
Okay.
can start eviction proceedings.
Got it. Lease violation, so anything that's within the lease.
Yeah, and that one's tougher, and we see this with just cause in the city of San Diego. If we're talking about nuisance complaints, things like that, noise complaints, what have you, you have to respond to your other residents to address those. But even if you give a 60-day under this law, you first have to give them an opportunity to cure. So similar kind of to what we already do as a practice, but in this case, if they do it again, then you can just give them notice to leave. The other thing is with lease violations and the like is it's very difficult to prove if you have to go to court. So if you give a 60-day because somebody's throwing wild parties all the time and then they don't budge, you're going to have to go to court to get possession. So essentially an eviction proceeding. Well, now you have to prove you have that cause. And written statements from neighbors are not admissible in court, so you need neighbors to come in and actually testify, and that's very difficult to make happen. Obviously, if you're a tenant and living next door to somebody who's dealing drugs or creating havoc, and they know where you live, you probably don't want to testify against them. But a lot of this is ultimately going to wind up in court, I think, to have to prove essentially you had the cause.
Yeah, that would be awkward.
Yeah.
Right? Testifying against your neighbors, especially if you all have to go home and live next to each other.
Yes.
Nobody wants to do that. And I guess that would also cover the criminal activity piece. So lease violations, criminal activity, non-payment of rent, those are what's considered at-fault termination. So those would be allowable under just cause, but hard to prove other than the non-payment of rent.
Right, and that's what we face today with your court process. So.
Has it been a huge challenge? Well, since San Diego has been under just cause eviction for how long now?
I want to say about 15 years.
Okay, so for some time.
Yeah, for a while.
Has it been an issue? I mean, I'm not a property manager. I'm a broker. So
I've heard some horror stories.
Yeah.
Yes,
Yeah.
and the I think the most unfortunate thing is that when you're in a situation where, let's say, you've given a problematic tenant a 60-day and they haven't budged, and now you're waiting for your day in court. In the meantime, your good residents are coming up and saying, what's going on? How come they're still here? And you can't really say anything as the owner or the manager except that I'm going through the proper channels, something like that. And what oftentimes ends up happening is the good residents who you want to stay exercise their right to give a 30-day and leave.
Wow, that's unfortunate.
It is.
No-fault terminations. Let's talk about no-fault terminations. No-fault terminations are defined as owner move-in, withdrawal from rental market, a habitability order from a government agency, and intent to demolish or substantially remodel. Okay, so no-fault termination, owner move-in. Owner wants to move in to one of the units. That's considered no-fault.
Right.
Okay, pretty obvious. Withdrawal from the rental market.
This scenario would probably be maybe condo conversions.
Okay, condo conversion or
Just selling the property altogether. I mean, usually they're still sold as investment properties, but condo
Gotcha.
conversions would certainly be.
a habitability order from a government agency.
Code compliance came in and they said this place needs to be red tagged. Everybody's got to go.
Got it. And then intent, this one's actually discussed a lot.
Yes.
It looks like you got a sub-bullet point here, so that's perfect. Intent to demolish or, and I'll underline, substantially remodel. So in our business, everybody's looking for value-add opportunities. They want to come in and they want to remodel these properties. And quite honestly, I go into a lot of these smaller properties in San Diego, and many of them need to be upgraded and remodeled. We know that our apartment stock here was built somewhere between 1960 to 1980. A lot of them are really in bad shape. These properties take a lot of wear and tear, and they need to be, some of them do need to be demolished, quite honestly, but they do need substantial remodel. So here we have a definition of substantial remodel, because we've talked about this even in our sales meetings at our office. What defines a substantial remodel? So you guys have defined it here, which is
Well,
good.
to be fair, this is the definition from the legislation itself.
Okay.
The legislature defined it.
Okay.
Yeah.
So let's see what they have to say. Substantially remodeled is defined as the replacement or substantial modification of any structural, electrical, plumbing, or mechanical system that requires a permit, from a governmental agency, or the abatement of hazardous materials, including lead-based paint, mold, or asbestos in accordance, this is long, with applicable federal, state, and local laws that cannot be reasonably accomplished in a safe manner with the intent in place, and that requires the tenant to vacate the residential real property for at least 30 days. Cosmetic improvements alone, including painting, decorating, and minor repairs, or other work that can be performed safely without having the residential real property vacated, do not qualify as substantial rehabilitation. So essentially, does it mean if you have to get a permit of some sort, that's considered substantial remodel?
The way I read it, because it says or and then it says and later. So it's either you're doing work that requires you to pull a permit and it's going to take at least 30 days, and the tenant can't remain there, or you are doing work that is going to require the abating of a hazard. And right now in our county, pretty much anytime you go and do anything in a property at this stage, you're having to test for asbestos and get a survey. So, and let's say you're going to do something in an older property that may have lead and may have asbestos, and that work is going to take so long, the tenant's going to have to be out for at least 30 days. That, I think, those scenarios would qualify as substantial rehab. And it's kind of similar to what we have already in the city of San Diego, where it talks about substantial remodel. And, a lot of owners call and say, well, what does that mean? And it can be very subjective, but we usually tell them, listen, it's got to be work that is going to render the unit uninhabitable for a time period and probably take at least 30 days, meaning you won't be able to have them in place, or you won't be able to relocate them, at a reasonable rate, essentially.
What's it going to do to cost? Because requiring a permit, that's going to take time. Getting a government agency involved, that means you're going to have an inspector come out, correct?
Well, I think that government agency one, that's if, let's say, a tenant calls code compliance and they find all kinds of things wrong, and then they come in and say, okay, this is not habitable, you've got to go. In the case of substantial remodel, it is up to the owner to figure out what they want to do, if that's going to involve permitting, testing, any kind of abatement, or remediation, and ultimately how long it's going to take to make sure that it meets this definition. Now, again, nothing, there is no AB 1482 police, essentially. There's really, the enforcement of this is going to be in the courts. And so we may not know some of the best practices right away. We may have to wait until there's some precedent. And I imagine that, there'll be a court case at some point to figure out what substantial remodel is or isn't, based on one kind of isolated case.
Understood. So the 30 days may have something to do with it as well, because it seems like right now with labor shortages, getting contractors out, small remodels, but small turns can take 30 days and have someone out of the unit for that period of time.
Yeah, so ultimately, how long it's going to take, and can they remain in the unit safely, and for how long? If you can stay here a week, but the rest of the work is not going to be livable for you, and that's going to take 5 weeks, well, I think you've met this definition.
Got it. Interesting. Okay. Next item. No fault terminations will trigger a relocation payment of 1 month's rent. Highly controversial. 1 month's rent regardless of the tenant's income. The last month's rent may also be waived. So you're going to do a remodel. You have to pay them 1 month rent or give them a free month? Is that what it comes down to?
Yeah. So Doug, I'm going to give you your 60-day with cause. I'm doing a substantial remodel. Within 15 days, I need to give you a payment equivalent to 1 month's rent, or we have to have agreed that in lieu of that, we'll just waive the last month's rent.
Okay, so let's break that down a little bit. I'm considering doing a substantial remodel on my unit. I give the tenant a 60-day notice to vacate. Within the 15 days of the time I've served the notice, I need to either give them 1 month's worth of rent in cash, or give them their last month of that 60 days for free.
Sign something that basically saying that you both agreed to waive the payment of the last month's rent.
Okay, got it.
Yeah.
So they have a choice to choose.
Right.
Okay.
Yeah, so it'll be interesting to see how that plays out. And part of the reason that we included regardless of the tenant's income, and I'll have to go back and double check if that language remained in the legislation, but one of the things that we often talk about with regards to rent control and some of these policies that surround it is there is no means testing for rent control. And oftentimes the folks who would benefit from it the most don't receive that benefit. It's largely based on where you are at the time that goes into effect. So, this goes into place and now your rents are capped at this amount, but in the meantime, your income doubles. You probably don't really need that benefit at that point. And guess what? Now your landlord's going to give you a 60-day with relocation. Do you really need that 1 month's rent to move? You are maybe a more affluent person at this point, So our point is what we were trying to get to is very similar to with rent control. We want to make sure we're actually helping the people who need it, right, and not just giving 1 month's rent willy-nilly, even to wealthy renters because of this law. But nevertheless, there's no means testing, so everybody potentially gets that benefit.
So means testing means
making sure you meet certain income qualifications.
Got it.
For instance, with affordable housing, there's different levels, and it's largely based on where you are in regards to the area median income.
Okay.
Yeah.
Got it. All right. Specific language and disclosures are required for exempt properties and when terminating tenancies. So now we're going to talk about what's exempted, what's not included under the rent cap bill. Number one on the list, single family homes and condos.
Yep.
got
So
those out.
very similar to what's in place with Costa-Hawkins and applicable in any rent control jurisdiction. Single-family homes or a condo where you own, just one in a building. The term that is used is alienable separate title. So, I only own one condo in this 10-unit building as opposed to owning the whole building or multiple condos. And that is ultimately what will get you that exemption. However, there are caveats that if they're owned by a real estate investment trust, a corporation, or an LLC where one of the members is a corporation, then those single-family homes and condos are not exempt.
So entity structure is important then, because some folks do own properties, maybe just one investment property under their corporation. Is that S Corp? Is that included?
So it is right now. We're hoping that next year we can do some cleanup language and get that exempted as well, because we know that's often used in this industry. What they really wanted to go after here, and you'll remember this was kind of a lot of the rhetoric during Prop 10, are the big corporate companies who came in and bought a bunch of single-family homes,
right, the big
and then
REITs,
were accused of jacking up the rents quite a bit. That kind of scenario.
So LLC, where one of the owners is a corporation. So most
LLCs don't
have
fall
an
into
owner.
that.
Right.
Yeah.
Okay. Got it. Owner-occupied duplexes. So you buy a duplex, you live in one of the units, you rent out the other units. It's not.
It's exempt.
Oh, it is exempt.
However,
Okay.
there is some language that essentially says the owner has to have lived there at the time the rental tenancy was created and maintain it as their residence. So if you have a duplex, you can't just move into one after a tenant's already been in place and only live there for a few months and then live somewhere else part-time and then try to claim the exemption. You have to have been in place at the time the tenant moved in and maintain that as your residence. And I think it's similar to what we see in some rent control jurisdictions that have language specific to duplexes and triplexes sometimes.
So this only includes duplexes. It does not include 3 or 4 unit buildings.
Right.
Okay, so it only includes duplexes. And a scenario where I buy a duplex, I move into one of the units, and the current tenant's already in there, they're not exempt. It still applies to them. But if someone moves in after I move in as the owner, then it wouldn't apply.
Correct.
Really? That's okay. That's confusing, but
As much of the bill.
all right. Next one. Housing built within the last 15 years determined by certificate of occupancy date. So anything that's less than 15-year-old, any housing.
It's the new construction exemption that was talked about a lot. But yeah, so it's, again, certificate of occupancy. So if you have a newer property, let's say, and this is something you have to be mindful of, but you've got a couple buildings, you have to remember that different buildings can get different dates of certificate of occupancy. I've even heard of different floors sometimes having different COO dates. So it's something to be mindful of if you have new construction and you're exempt. Pay close attention to your certificates of occupancy because it is a rolling kind of 15 years. You will at some point be folded into this if it, if they're younger than 10 years or if they unsunset this. Is that a word?
Yeah, that's
Re-up? There you go.
Could be. All right, so 15 years. Next one is housing subject to a local rent control ordinance. Local ordinance and Costa-Hawkins apply, i.e. Palm Springs. So help us understand local rental control ordinance.
So what we have now, or what we're going to have soon, is kind of multiple layers of different rental practices. So in our region, we don't have any local rent control, so it will be the statewide law and then the properties that aren't covered or exempt. But if you're in LA, for instance, they have a local rent control ordinance. Properties not subject to that fall under AB 1482 will be subject to that. And then you have the exempt properties. The housing subject to local rent control will still be governed by Costa-Hawkins. and that means it can't apply to single-family homes and condos. Vacancy control remains intact. So those things that, again, we fought so hard to protect last year. So if you're in a rent control jurisdiction, pretty much everything is going to stay the same there if they're covered by that particular ordinance.
Okay, let's dig into that a little bit more, because Costa-Hawkins is something that we did preserve, and maybe explain it a little more in detail. So Costa-Hawkins was basically three things. What were those three things that it preserves?
It exempts single-family homes and condos from rent control. It exempts anything built since 1995, essentially, and it mandates vacancy decontrol.
How does this blend in with Costa-Hawkins, or how does one cover the other? Or
They don't really overlap.
Okay.
Like you said, so rent control, a local rent control ordinance is bound to the rules of Costa-Hawkins. Anything not covered by that will be under 1482. And then if they're exempt from both, they're out doing whatever.
Okay, got it.
Yeah, so it's kind of a patchwork of different rules, and then if you're in certain jurisdictions, it can be even tougher.
Right, so Costa-Hawkins single family, this doesn't affect single family unless you own more than 10. And then the 1995 versus
There is no 10 unit.
That got pulled out?
That did. It's unless you're exempt unless they're owned by those entities.
So they switched it to entities.
They took out the unit threshold.
My mistake then. So you can be an individual owner and own more than 10 single family.
Yes.
As long as you don't own it as a corporation or one of these entities.
Correct.
Okay, that's interesting. It's one change I wasn't aware of. So Costa-Hawkins 95 versus 15 years ago. So 15 years ago would essentially be 2004. Costa-Hawkins protects buildings up to 1995. So Costa-Hawkins would take precedence in that situation?
Again, so Costa-Hawkins is a state law that exists to govern local rent control jurisdictions.
Okay.
So the LA, San Francisco, Santa Monica, the places that have rent control, those are still going to pretty much remain the same and stay governed by Costa-Hawkins.
Okay.
If you're not under a local rent control jurisdiction, you're under AB 1482, unless there's exemptions.
So Costa-Hawkins only applied if there was a local rent control
Yes.
jurisdiction going on.
Absolutely.
Otherwise, it's off the table and you're under AB 1482.
Right. Now
Okay.
we do see kind of some, bits in here that resemble Costa-Hawkins. And I think that sometimes might lead to confusion and, for instance, vacancy decontrol.
Right.
Using that phrase, which is really specific to Costa-Hawkins, but we did so much work in the last, year or so to educate people on that term that we want to keep it at the forefront and make sure people understand that even with 1482, you have vacancy decontrol still.
So a local jurisdiction cannot go ahead and implement anything even more harsh because Costa-Hawkins may kick in at that point.
Actually, well, yes and no. Let's take San Diego for an example.
Okay.
The city of San Diego can implement rent control,
Okay.
but it's going to be subject to the rules of Costa-Hawkins, meaning it wouldn't be able to apply to anything after 95, single-family homes, and we'd be able to reset rents at turnover.
Okay. Got it.
So they can.
So it's just those
yeah.
three items that Costa-Hawkins affects.
Right.
Okay.
But of course, we know that local rent control jurisdictions, they also have a whole other slew of rules that aren't governed by Costa-Hawkins. So.
Got it. Okay. Dormitories. Okay, so student housing, dorms
Yep.
will not be rent control. I'm sure all the parents are upset about that because rents will
Well, no, they
continuously
just
go up.
co-sign and they go live in houses with roommates.
Yeah, and then turn over every summer.
Yeah.
We've dealt with that. So what is a dormitory? I mean, what would they classify as a dormitory?
It's interesting. There is a definition, and it's not necessarily limited to a university. I guess there are some scenarios where students live on campuses, so those would be exempt too. So any campus or education institution that has housing essentially that they provide.
Would an SRO be considered a dormitory, a single room occupancy where you're just renting a room and you're...
No, because the bill language is specific to education institutions
Okay.
with regards to dorms.
All right. This next one has an asterisk. Owner-occupied properties where no more than 2 bedrooms are rented are excluded from the just cause provision. This includes granny flats. Okay, so granny flats, ADUs, and if you're renting a couple rooms out, no more than 2 rooms out in
Right.
your house, they're excluded.
From the just cause provisions. And it makes sense, right? If you're going to rent rooms out in your home where you live, or, you know, the house attached or what have you, you want the ability to be able to terminate that tenancy if that relationship becomes tenuous or something, you know, nefarious is going on, versus having to give a 60-day and go through those legal challenges because that owner is actually living in the unit versus just renting it from the owner.
Okay, so we're talking about exemptions that apply to all of AB 1482, but in here you put just cause provisions. Does that mean that owner-occupied properties with rooms rented would fall under the rental increase cap?
No, so if you rent rooms in your house, you're already exempt because it's a single-family home.
Right.
So
Got it. Okay.
yeah, so this is specific to a scenario where you might be in a living situation where if it got dicey, you'd want to be able to easily terminate a tenancy.
Got it. And ADUs, because they're usually
Right.
on property. Okay, that's the end of this list. Is there anything on the other side that we should talk
The
about?
last thing I do want to say, well, first, let me back up. Deed restricted housing is exempt from this law, and that is your affordable housing, subsidized housing where you have an agreement in place, you know, or tax credits or what have you. They are essentially already rent controlled for a certain duration, usually up to 55 years, and there are specific rules on if those covenants expire on what property owners have to do. The other thing is the legislation, they added language towards the end which essentially says any just cause ordinance that was in place prior to September 1 of this year is exempt, meaning the city of San Diego's just cause ordinance remains as is, at least for now. There are attempts to alter it, and I imagine they'll probably change it to mimic state law now. But nevertheless, those folks with properties in the city of San Diego who are used to operating under that just cause can stay operating under that just cause for the time being. And one thing about the city's ordinance, it doesn't require relocation for no fault cause.
Ah, okay. So is that one take precedence over AB 1482?
I wouldn't say it takes precedent, but it remains as is.
Okay.
AB 1482 in terms of just cause doesn't apply there because of that language that kind of exempts them.
Okay.
Yeah.
I guess that's a positive note if you were...
Yes, but
Makes sense.
again, I know for a fact that there are attempts. So there were attempts prior to this passing, or at least, you know, there have been discussions about changing the timeline in the city of San Diego. And there's been talk, you know, having it kick in at 1 year. Some people have said have it kick in as soon as 30 days. And then there's also talk about potential relocation fees.
So they're going to try to change it.
Probably.
I noticed senior housing is not on here. Is senior housing exempt, or is that something that's way outside of the realm of what we're even talking about
If
here?
it's deed restricted or has any kind of subsidies
Like
in
55
place,
and over,
yeah.
things
But
of
if
that
it's
nature?
market rate housing, but it's just restricted for age, I don't think so.
Okay. All right, so that's a rundown of AB 1482. I thought we were pretty thorough. I'm sure there's still a bunch of questions.
Oh gosh, you can ask any question,
Yes, and there's gonna
we
be-
could go on forever with this.
Oh yeah, there's probably a lot of what ifs, I'm sure. And I'm sure you're getting a lot of those what ifs in your classes. So again, you're
Yes.
hosting classes. We don't have the dates, but we're going to put a link to the dates of those classes, and it's through the Southern California Rental Housing Association. And then Molly, before we jump off, I just received an email from you guys talking about some of the other bills that were signed.
Oh, yeah.
I mean, we don't need to go another hour, but are there any that are stand out that we should really also talk about? I mean, everybody's been focused on the AB 1482, but what about some of these other items that have popped up?
You're absolutely right. 1482 is kind of taken all the thunder away, but there were other bills that were signed as part of the tenant protection package by the governor. One of the major ones is SB 329, which for folks in the city of San Diego who are aware of the ordinance, the source of income discrimination ordinance, state law has basically added vouchers, whether it's Section 8, VASH, or some other kind of government payment like that, to these protected sources of income in California, meaning, much like the city of San Diego, every property owner or manager in the state is now going to have to consider Section 8 applicants. Yeah, so gone are the days of, sorry, we don't participate in Section 8 in your ad, no Section 8 or things like that. So if people call, make sure, well, it's not effective until January 1. Make sure you're letting tenants know we don't participate now, but we are prepared to, participate come January 1.
Got it. So change your ads if you have no Section 8 in your ads.
Absolutely.
Across
please,
the board.
Yes, please do that. Because we know right now in the city of San Diego, their ordinance became enforceable on August 1, and there have been dozens of lawsuits already for property owners, quite a few who just weren't aware of the law or just forgot to change their ad. The other one that I think is important that was kind of part of a package with SB 329 was SB 222, and it adds veterans or military status to the list of protected classes, so you can't discriminate against somebody for being either, essentially, which you shouldn't be doing anyway.
Right. Good news is military folks don't get discriminated against quite often.
No, well, there is a federal statute that allows active duty military, if they're deployed or given orders to move, to get out of leases. And there was, and I'll talk about this other legislation in a second, but some people are thinking that there were landlords who were saying, I don't want to have to deal with you breaking my lease potentially, so I'm not going to rent to you. I've never heard of that happening, but that was the story we kind of got from Sacramento, which leads to SB 644 Glazer. This basically limits security deposits for active duty military to 1 month's rent. Whereas under current state law, you can charge up to 2 months rent for a security deposit. So if they're moving in with other active duty military or their dependents, you're limited to that 1 month's rent and security deposit. If they're moving in with roommates who are civilians, then it doesn't apply.
Wow, that's a big one since we are such a military town.
And you raise a great point. When this bill came up, we kind of were very shocked because this particular legislator is from Northern California, as I understand, and we are the largest military region, and we've never heard anything along these lines. And what he claimed was that active duty military was having trouble getting housing because they have to pay the first month's rent and the security deposit that is oftentimes 2 times the rent, and that it was making it difficult for military personnel to get into housing. Now, that may have been true up there, but we, like I said, didn't hear anything like that here. So we were concerned that maybe that should have just been a district-only bill for a time being, or something along those lines. And then really quickly, AB 1110 has to do with noticing periods for rent increases. So under 10%, it's a 30-day notice and change in terms. Going forward, if you're able to do an increase of more than 10%, you're going to have to give your tenants 90-day notice.
Oh, okay. Currently it's 60 days, right?
Right.
But under the current bill, you wouldn't be able to go above 10% anyways,
It's going to be those exempt folks or the new construction that would be
so it would be like a
subject to
single-family house. If you're giving someone a over 10% increase on your single-family house,
They get 90 days notice.
they get 90-day notice.
Yeah.
Good to know.
And it started off with 30, 90, 120. And we said, where'd 60 go? And they kind of altered it, but 60's still gone. And this is going to create some issues in operations because 30 and 60 days have been those standard time frames for so long that it'll be interesting to see how this plays out.
Wow. The books are going to have to get rewritten.
Yep. Lots of them.
Wow. Anything else that you want to get out there to the viewers?
I just want to say thank you to all the members and non-members who supported us and wrote letters and sent emails, made phone calls. It's very important. Even though the bill passed, trust me, your voice was heard when you start hearing that legislators and their staffers are annoyed by the calls and emails, that means we've done our job to a certain extent. And just keep up the good fight, because this is not over. If you don't know, Mr. Weinstein, who bankrolled Prop 10 last year, is collecting signatures. He's actually been qualified, but he's still collecting more signatures just to make sure. And we will be facing another attack on Costa-Hawkins on the 2020 ballot.
Wow.
Yeah.
We just fought that one.
I know. It's coming back.
Well, if you are not a member of the Southern California Rental Housing Association and you own any type of rental property within the Southern California region, I strongly encourage all of the owners I talk to on a regular basis that they should join. These folks are here. They're fighting a good fight for you. And as you can see with all of the stuff that we're having to deal with here in California, specifically in Southern California, we need every bit of support that we can get. So we're going to put a couple links in the description down below on where you can find out more information about the classes, and also how you could possibly join the Southern California Rental Housing Association, because quite frankly, it's your industry and they're the ones that are fighting for your rights as owners. So, Molly Kirkland, Director of Public Affairs, thank you for spending this time with us.
Happy to do it. Thanks for allowing me.
Yes, you're amazingly insightful, and thanks for just knowing all of this, because it is certainly confusing.
It is very confusing, but it's what we have, and we've all got to learn to kind of operate in this new landscape. So.
Yeah. Well, and thanks to you guys, it makes it a little bit easier.
I hope so.
All right. All right, thanks guys.